Good morning, friends. Has your FCRA renewal been denied? Are you still wondering what needs to be done to restore your registration? Don't worry. I am Ashis Agarwal from Team NGOenabler, and in today's video we will guide and handle you on what you need to do if your FCRA renewal is rejected. To give you a brief background on rejections of FCRA renewal, as per the latest available data, almost over 7,500 organizations were denied renewal in financial year 23-24 by the Ministry of Home Affairs. It's huge. Really, a vast number of them have lost their FCRA license and are facing tough times to run their organizations solely on local funds. Recently, a notification was released by the FCRA department where it has consolidated and laid out various reasons for denial and refusal of application for registrations or renewals, giving an illustrative list of the same. We have already released a video covering in detail about the notification and providing clarity on the reasons why your FCRA renewal must have been denied by the department. If you have missed it, watch it now by clicking the I button on the screen. Coming back to the topic, let's understand what should be the way forward once your FCRA renewal has been denied. At first, the organization should thoroughly examine the reason or reasons for denial, specifically in the light of the notification released by the FCRA department. If the reasons are not mentioned specifically in the denial order and only the relevant section has been mentioned, the illustrative list of the sections with explanations as mentioned in that notification shall provide clarity on the reason for denial. Alternatively, you can also contact any professional expert who shall interpret the provisions of that relevant section for you, highlighting the possible reasons for denial. But what if it's only mentioned that due to non-submission of response to clarification or non-uploading of documents required in the clarification, the renewal has been denied? In our opinion, though the renewal has been prima facie, seems to have been denied due to non-responding to the clarification requested by the ministry, but the actual reason might be clear from the clarification itself that was requested by the department. In the clarification, the department usually asks for some documents or details and give certain specified number of days for filing the response. If the organization misses upon it, the department, due to such non-submission, denies the renewal. It might seem harsh, but that is how it is. So after knowing the reason behind denial, the next step for the organization is to start compiling the documents which were lacking and take corrective measures wherever required and to the extent possible to resolve the concerns and discrepancies or deficiencies raised in the clarification. For example, if the renewal has been denied for not filing the relevant forms for change in executive committee members or opening of utilization bank account, the organization should first compile the details and file the relevant form on the FCRA portal. The organization should ensure that it is compliant with all the FCRA rules and regulations before moving forward to the next step towards restoration of registration. Now comes the most important and vital step of the restoration process. Having analyzed the reasons for denial and taking corrective measures wherever possible, the ultimate step is to file a revision petition under Section 32 of the Foreign Contribution Regulation Act. The revision petition can be filed online and the time limit for filing the petition is within 1 year from the date of the order. I repeat, the revision petition can be filed online on the FCRA portal and the time limit for filing the petition is within 1 year from the date of order. A proper and detailed submission needs to be prepared for providing clarification on each point raised by the department for denial. The submission should be supported with complete and proper documentation to substantiate that no non-compliance as set forth in the order actually exists. Yes, there might be certain violations, but most of it would be compoundable offense which can be compounded by paying certain penalty as laid down in the Act. Not necessarily, such violations mandate cancellation or denial of registration or renewal. The organization need to provide detailed explanation point by point, providing all the necessary documentation, thereby requesting the FCRA department to reconsider and revisit their order. Alternatively, a petition can even be filed in the jurisdictional high court, but when the Act have given a recourse of filing the revision petition with the FCRA department itself, we should first consider doing that rather than directly approaching the High Court. There are high chances that such cases might be set aside and the court shall ask the organization to consider filing the revision petition first rather than approaching the court for justice. Apart from filing a revision petition or petition with the High Court, the organization can also apply afresh for the registration under the Act. Remember, denial of renewal does not equal to cancellation of registration. I repeat, denial of renewal does not equal to cancellation of registration. The status on the FCRA portal shall show deemed to be seized instead of cancelled. In case of cancellation, there is a lock-in period of 3 years before you can reapply for fresh registration. However, in case of denial of renewal, one can immediately reapply for fresh FCRA registration. Also remember, once your FCRA renewal has been denied, immediately instruct all the banks in which you are operating the FCRA accounts to freeze both credit and debit transactions. I repeat, once your FCRA renewal has been denied, immediately instruct all the banks in which you are operating the FCRA accounts to freeze both credit and debit transactions, because both receipt and utilization of FCRA funds after the denial of renewal is a major violation of the Act. In this regard too, a notification has been released recently by the Ministry of Home Affairs, which we will discuss in our next upcoming video. So by now, you all must be aware that the rejection of FCRA registration or renewal can be a significant setback for many organizations, and restoring it back is all the more challenging. However, by understanding the grounds of rejection, utilizing available legal remedies, and effectively preparing a revision application, organizations can improve their chances of a favorable outcome. I hope you have been able to provide clarity on what should be done once your FCRA renewal is denied. For more such updates and tutorials, keep watching our channel. Don't forget to subscribe it and put your notifications on. You can also follow us on Facebook, Twitter, Instagram and LinkedIn. Thank you.